You are muted.
Good afternoon, President. The Caribbean Court of Justice, Original Jurisdiction. Hearing of application in TTNOG 2026-001 between Tonya D'Almada and the State of Trinidad and Tobago, the State of Jamaica, and the Caribbean Community. The members of the panel are the Honorable Mr. Justice Anderson, President and Presiding Judge.
Good afternoon, everyone.
The Honorable Madam Justice Rajnath Lee.
Good morning, everyone. Good afternoon, I should say, everyone.
The Honorable Mr. Justice Barrow.
Good afternoon, all.
The Honorable Madam Justice Anonewu.
Good afternoon, everyone.
And the Honorable Mr. Justice Vulcan.
Good afternoon, everyone.
Counsel, you may now enter your appearances.
Should it please the court, for the applicants, we are led by Mr. Lee Merry, Senior Counsel, who is unavoidably absent today. I am Kashka Hemans, Junior Counsel, and we are instructed by Mr. Lee Boyer.
Thank you, Counsel. Just to get it right, did you say for the applicants or for the applicant?
I can't recall, but I mean the applicant.
Okay, wonderful.
I mean the applicant.
Yes, I want to make sure we have the right number of applicants. Thank you very much. For the first respondent.
Good afternoon, Your Honors. My name is Sanjeev Lala, and appearing with me is Ms. Shalvi Ramkisoon and Mr. Mavani Oja Maraj. And we are instructed by Ms. Janine Joseph and Claire Thomas Medina, and we appear on behalf of the first respondent, the State of Trinidad and Tobago.
Thank you, Mr. Lala. For the second respondent.
If it so pleases you, appearing on behalf of the second respondent, Faith Hall. Appearing with me, Miss Sharice Gale, as well as Miss Shelley-Ann Thompson, and we are instructed by the Director of State Proceedings.
Thank you very much, ma'am. And for the Caribbean Community? Is there an appearance for the Caribbean Community?
My apologies, President. I'm Radha Permanand, and with me is Mr. O'Neill Francis, and we appear for the Caribbean Community, the third respondent.
Thank you very much, ma'am. Very well. So thank you for those appearances. We are in a case management conference. The purpose of the CMC is to consider an application by the applicant for special leave to commence proceedings against the three named respondents' proposed defendants. I think by order of the court given earlier, you were advised that the applicant will have 30 minutes to present the case for the application, and the respondents will each have 30 minutes to refute that case if they so wish. Are you ready, Mr. Hemans, to present the arguments for the applicant?
Yes, Your Honor.
Please.
Good afternoon again to everyone. Firstly, I wish to indicate I don't expect to use all of the 30 minutes. I mean, subject, of course, to any questions that the court may have. And we stand substantially on our written submissions, and perhaps just wish to highlight a few points that are contained in, highlight and flesh out a few points that are contained there. As we see it, Your Honor, the issue at this stage is that it is arguable that the applicant's treaty right to freedom of movement was prejudiced by the sharing, retention, management, and use of inaccurate or incomplete or outdated security intelligence information concerning what was at the time an acquitted criminal charge. We think it is relevant to remind the court that at this stage, the purpose in considering whether to grant special leave, the applicant is required only to show that there's an arguable case that there was a breach of her treaty rights. There is respondents. We note, for instance, that the respondents have made certain what we consider to be impermissible submissions that cannot touch on concern evidence. There's not been any evidential testing. They've invited the court to consider that the information was lawfully obtained, it was accurately maintained, it was updated, and our contention is that at this stage the court should not be going into the merits. The court should be looking primarily at the case as presented by the applicant and determining on the basis of the evidence that presented there whether or not the applicant has met what this court has previously conceded is a low test, not inconsequential, but it's a low bar. It is simply arguability, and we think that we have demonstrated that we have met that test. Now, that matter of the threshold is relevant also, we think, to the nature and scope of the treaty right that is engaged. The right to freedom of movement, it is set out in the Regional Treaty of Chaguaramas at Article 45. It's further fleshed out in the 2007 conference decision, and again further fleshed out in the Shanique Myrie case and the jurisprudence of the CCJ more broadly. So it is not simply a right to move from point A to point B. Contained in that right is a qualitative element, that freedom of movement must be hassle-free. So each CARICOM national has a right to enter, to travel to enter, and to stay in another member state. And that entry should be without hassle. The stay should be hassle-free and without harassment or the imposition of impediments. And we note that Jamaica in particular and the state of Trinidad and, well, the respondents more broadly have set up Shanique, the condition in Shanique Myrie as a threshold. But we're suggesting that there is some treatment that falls below what happened to Shanique Myrie that would nonetheless amount to a breach of the treaty. The factual circumstances in this case show that you had a Trinidadian national who traveled to Jamaica. She was subjected to what we're calling here non-routine border treatment, to the extent that she was taken into a separate room. She was traveling with work colleagues. Those work colleagues were detained. She was questioned for going on for half an hour on the basis of what we are alleging was inaccurate or outdated information that was contained on a regional watch list or database. The authorities in Jamaica questioned the applicant about her criminal past, her criminal conviction, her criminal charge, I beg your pardon. And on the basis of that questioning, they verified for themselves then that she had been acquitted of the charge, and thereafter they admitted her. We're suggesting that that treatment at the border was not in compliance with the Regional Treaty of Chaguaramas. And we don't say this to suggest that it is unlawful without more for a border official to pose questions and to determine whether a CARICOM national should be allowed entry. We're suggesting though that anything that is non-routine, like once you step outside the boundaries of just ordinary information gathering to determine, one, that the person is in fact a CARICOM national. Two, you can probably ask them, where they're staying. I think once you move into taking them into another room, once you start asking them about criminal conduct, that you then have to justify it within the context of the very narrow exceptions that are provided for under the treaty. So yes, is it you need to determine, you have to be satisfy yourself that the person poses a continuing security threat. And it is not clear that in circumstances where it's not clear that the mere fact of a previous criminal charge is enough to subject a CARICOM national who has a right of entry into another member state to submit that person to non-routine treatment at the border. The prejudice we suggest is clear. There's a whole matter of being singled out. There is the delay. There is the matter of the questioning. There's a matter of the embarrassment that would be involved in having, being questioned in circumstances where your work colleagues are present. But beyond that, there's also the issue of the continuing hindrance to the freedom of movement that would be caused by the applicant's continued inclusion, her data continuing to be included in this database. We're suggesting that it is that all of those facts satisfy the test of arguability that she will continue to suffer a prejudice, one, and that she has already suffered a prejudice. And in terms of liability, I think again, keeping the nature and scope of the right to freedom of movement in mind, and accepting, as we ask this court to do, that it is not, the right is not simply this mechanical thing of allowing a CARICOM national to enter another member state. It involves, as we said, this qualitative aspect. And once you accept that that is so, then you can see that conduct that relates, any conduct that touches and concerns or could have a bearing rather on the kind of treatment that a CARICOM national will receive at a border is relevant in determining whether or not there has been a breach. and in kind of more direct and practical terms, using the case that we've made against Trinidad as a first protocol. Our case is that Trinidad and Tobago clearly shared certain information about the applicant, and we're not sure, we're not clear exactly what was shared, but it had something to do with the applicant's criminal charge. That charge was leveled in 2016. Applicant was acquitted in 2020, I beg your pardon, and up to 2022, there was no mention in the database that the applicant had been acquitted. Now, I mean, based on CARICOM submissions, it's not in evidence, but we're going to take the submissions of CARICOM and when I think they cited the MOU, which suggested that Trinidad and Tobago had a duty to, or not Trinidad and Tobago, the country that shares the information has a duty to update that information. And I think that it is arguable that the information was not updated at the time it was utilized, and that to the extent that Trinidad and Tobago did have a duty to update, that failure to update amounted to a breach of the applicant's right to freedom of movement.
Mr. Hemmons, I just wanted to seek clarity on a couple of points you made.
Please.
The first, I'm going to take you back shortly and then come back to where you were. The first, my understanding is, my takeaway from your submissions on the question of whether there was prejudice in the enjoyment of a right that Ms. D'Almada had or has under the treaty. I take it from your submissions that what supports your contention is that there can be prejudice in the enjoyment of the right to freedom of movement, even where the national is allowed to enter the member state.
Yes, Your Honor, because there's this qualitative element of hassle-free entry. So the fact that you allow for instance, you could be subjected to any manner of indignities at a border and then subsequently admitted. That would not be treaty compliant, because there is this very important component of hassle-free entry.
And Mr. Hemmons, thank you. Oh, I'm sorry. Do you want to continue?
I suppose, and what I would say, that qualitative element also, we are suggesting, extends even beyond the act of attempting to enter a territory.
Thank you, Mr. Hemmons. My second question is, you have spoken to, in relation to the state of Trinidad and Tobago, you've spoken to a duty that state has to share information that is accurate. And I wanted to quickly ask you, how do you think that duty arises in relation to essentially a right that Trinidad and Tobago would have under Article 45, the 2007 conference decision, to essentially have its nationals enter another member state hassle-free? So you've spoken to Ms. D'Almada having a right under the treaty to freedom of movement, involving the right to enter and stay in a member state hassle-free and without impediment or harassment. How does that right correlate to or translate to a duty that Ms. D'Almada's own state has to her? Thank you.
Okay, Your Honor, I I'm going to answer. I'm going to attempt to answer the question this way. And if please, if I don't hit the mark, please kind of indicate. So, I think the best way to answer that question is to look at the nature of the right of freedom of movement. It, as we said before, there is this qualitative element relating to border treatment. And in the context of a regional mechanism that shares advanced passenger information that is going to be used, that is going to foreseeably used by border officials to make decisions about whether or not they're going to allow entry, one, and also where they're going to make decisions about border treatment, then if Trinidad is placing information onto a database about a national, the duty they have to ensure that that process is itself treaty compliant. They have to ensure that that process is treaty compliant. Again, because the information that is shared, and in this case, it was information relating to a drug charge. That is obviously going to trigger a certain kind of treatment at the border of a member state. And if there has been a change of circumstances, like in this case, an acquittal after a full trial, that acquittal is highly relevant to be well placed on the database. There is also a question of whether or not the information should be removed entirely in the case of acquittal. Because again, we are not dealing with a situation where the information is going to be used for just general immigration considerations or general considerations of border treatment. We're talking about a special category here. We're talking about individuals who are CARICOM nationals who have a right of direct entry. And as such, there is a heightened requirement, we are suggesting, for circumspection in how you go about making decisions relating to entry and relating to border treatment.
Thank you, Mr. Hemans.
Mr. Hemans,
Right.
I should have jumped in after my sister's first question.
That's fine, Your Honor.
But I am.
You're muted, Your Honor.
Sorry, I was saying I wanted to return to your answer to my sister's first question. And what I take it your position that prejudice isn't necessarily confined to a denial of the right. If I understand you, you said there's a qualitative aspect to it. Now,
denial of entry, Your Honor.
Sorry?
Denial of entry, Your Honor.
Yes.
Right.
Denial, yes. So and you stress this element of a qualitative aspect to the right, the hassle-free. Now, I don't think that the respondents are necessarily contesting that. But what they have said, I think almost uniformly across the board, there's no violation here because, and some of them have gone so far as to say, well, this is far removed from MyRe. There was no cavity search. So there's no violation. I'm curious in the face of that quote unquote answer. Do you have sort of an idea of the test or the approach to the scope of this right in terms of a violation? Is the bar a MyRe bar necessarily where Or say if you weren't, violated physically, then there's no hassle. But I'm thinking more at the level of establishing a violation in the context of the scope of the right. So how far do we have to go before we say the right is violated? I'm not sure if you're with me.
I am with you, because that was something that I found. I mean, the submissions from my learned friends were well presented, but I was a little concerned that Myri was seemed to be Myri was being set up as a threshold, as opposed to hopefully the most egregious kind of breaches that we would see. So our case is that there's treatment that falls well below Myri that could nonetheless amount to a breach of the right to freedom of movement. And also that there are breaches that even if they do not involve significant or egregious physical harm, are nonetheless consequential, or nonetheless similarly consequential to Myri, because of how many people a breach could potentially touch. In this case, we're talking about the sharing of advanced passenger information of every single person who travels in the region, and some proportion of those individuals may have had a past running with the law. It is absolutely relevant for this court, we suggest, to. I mean, let me not go that broadly. Let me put it this way.
You're saying that the net of
The net
travelers could be wide.
It's extremely wide, and it is no less consequential because we didn't have egregious conduct. And we're not alleging that there was egregious conduct in this case. We're alleging that there was unlawful conduct, that there was conduct that was in breach of the treaty. Now, I've given it thought, and the honest answer is I do not yet know what a definite or precise test would be of the threshold. But what I've intimated before is that once you get into non-routine border treatment, you are then triggering the exceptions. And once you trigger those exceptions, then you have to be able to justify that conduct is proportionate. That is as far. But to try to say it would be difficult or challenging to get at a precise test, because there are so many circumstances that can arise in any given state. We're suggesting here that the suggestion that half an hour is not a big deal, we don't accept that. The suggestion that being taken into a separate room can be treated as standard at border entry. We do not agree with that intimation. It wasn't openly contended, but it was intimated in the respondent submissions. Further, we do not agree that having your party of your fellow work colleagues being detained, and the embarrassment that is occasioned by that can ever be treated as standard or treaty compliant behavior. And this is not to suggest that it is that such treatment is necessarily unlawful. What we are saying, though, is that such treatment has to be justified in circumstances where we are not dealing with a courtesy that is granted. It is not a courtesy that is granted to a CARICOM national when they arrive at a border of a member state. It is a right. And if you are going to derogate from it at all, it has to be, you have to do that. It has to be justified.
Thank you, Mr. Hewins.
Yes. There's just a few I think I've covered the Trinidad and the arguments of the state of Trinidad and Tobago. In terms of what I'm trying to do is to map out the the breach. The breach involved three entities as we see it. On the one hand, we have Trinidad and Tobago that shared the information. On the other, we have CARICOM, which we'll get to last. We have CARICOM, and I'll flesh that out later. And then we have Jamaica that used the information. And in Jamaica's submissions, again, they're not permissible submissions to the extent that they attempted to argue evidence, but in their submissions or admissions, they have said that that the officials were alerted by JRCC impacts that the applicant might pose a threat because of past issues with the law, and that they interviewed the applicant to verify that information. And this to us is confirmation that the border treatment was triggered by, it's an admission by Jamaica that the border treatment was triggered by the regional security information. And it raises an arguable issue as to whether Jamaica had a sufficient, accurate, and proportionate basis for non-routine adverse treatment. It is not enough for Jamaica to say, well, the information that was on the database showed that she had a pending charge. It is arguable, again, referring to the standard, it is arguable that Jamaica has a duty to verify that the information is accurate.
Very well.
Also,
Counsel, I believe we fully follow you on that point. Did you wish to make the case against the other two respondents, proposed defendants?
well, just the other one,
quickly.
CARICOM.
Yes.
So we think that claim against CARICOM is properly maintained because the applicant's complaint is not confined to just an isolated operational act of impacts, because obviously impacts looms large, and we note the concerns raised by CARICOM regarding the status of impacts, but our concerns relate to the absence of what appear to be a treaty-compliant community framework for the management and use of security intelligence information that affects freedom of movement. And this includes policy, safeguards, updating, correction, and verification. And there's an arguable case that these are matters that are broader than just simply impacts. And that is why we suggest that CARICOM as a whole is properly joined.
Very well.
And
that is, we follow you on that as well. Did you make the case against Trinidad already, or do you wish to do so now?
Well, I mean, our case against Trinidad, Your Honor, is that we're not suggesting that it is like it's a vicarious liability issue at all. It is that Trinidad shared information about the applicant that could foreseeably impact on border treatment, that it is apparent, or it is clear that having shared information relating to the charge, Trinidad failed to update that information after the charge was the applicant was acquitted, and the applicant was acquitted. That is the I think that's the extent of the case against Trinidad, Jamaica, CARICOM.
Very well. Could we hear you for just a minute on costs? If your application is granted, I believe that you'd be okay with costs, the issue of costs being folded into the hearing on the merits, I assume.
Yes, Your Honor.
And if you're unsuccessful, what is your view on the issue of cost? Very briefly, please.
Well, I mean, on the issue of cost, I think it would be open to the court to look at the pre-application conduct of the parties. This is a case where the claimant did make attempts to obtain information regarding the mechanisms involved in the sharing of the information. That wasn't forthcoming either from Trinidad, that wasn't forthcoming from the state of Jamaica. And I think also that in terms of this is not it was not frivolous matter, and certainly there were relevant issues to potentially be ventilated, and as such, there should be a favorable cost award, meaning there should be no orders to cost in light of this. And to the extent that the applicant is assisting the court in kind of fleshing out its jurisdiction, it is still a new court. I don't know that the court should take a step that would create a chilling effect on applicants who are trying to pursue what are genuine, non-trivial applications of the treaty.
Excellent. Thank you very much, counsel. Can we stop you there until the reply, if any?
Absolutely, Your Honor.
Wonderful. Appreciate it. Thank you. Counsel for the second, I'm sorry, let's start with the first. The first respondent, please. Is that Mr. Lala?
It is, Your Honor. Thank you very much.
Yes, thank you.
Your Honor, if I may be permitted, this is a case that has been brought in the Revised Treaty of Chaguaramas in this original jurisdiction where the applicant is challenging and alleging that a treaty right, i.e. the freedom of movement, was breached. The question that the hurdle my friend has to cross is whether there is in fact an arguable case that there was a breach of a treaty right to which the applicant was prejudiced to it. So my first point, Your Honor, is that the treaty right that my friend speaks of, we've submitted that there was no breach of a treaty right insofar as the state of Trinidad and Tobago is concerned, for the simple reason that the freedom of movement, as it's interpreted under the Revised Treaty of Chaguaramas, is of a national of one state entering another state of CARICOM. So it's not really against a national of its own state entering Trinidad, which is not in this case. It's really the movement of a national entering another CARICOM member state. On that basis, my friend would not be able to cross the threshold in regards to Trinidad and Tobago that there was a breach of freedom of movement, or a breach of the treaty right of Section 45, Article 45 of the Revised Treaty of Chaguaramas. Trinidad was not the state that the applicant was entering into. I'm relying on the Shanique Mary case of Barbados, which cites at paragraph 6 of our submissions. It's at page 2296 of the documents that have been filed before the court. And it's clear in that judgment and the reading of the court is that the full extent of the right to freedom of movement is that both entry and stay of a community national in another member state must not only be definite, but also hassle-free without harassment or the imposition of impediments. So, Your Honor, my submission on the very first point is that it is between a travel between one national entering into another CARICOM member state, and that's would not be applicable.
Lala, if I may, Mr. Lala,
yes,
if I may, to break up the claim like this in these discrete ways, I think doesn't do justice to what the applicant seems to be saying, and I'd like your thoughts really on squarely on what they're alleging. And clearly Jamaica is the state that refused that where this occurred, but the case of the case that the applicant is seeking to bring is saying that what Jamaica did was precipitated by the system in which Trinidad took part. And that system is this sharing of data for national security purposes, admittedly, but the sharing of data. And so what happened, because the data was incomplete or not updated that led to the incident in question. So let's not just narrow it down to the actions of the Jamaican immigration authorities. The applicant's case is also predicated on this system of sharing information.
Thank you, Your Honor. I understand exactly the concern that Your Honor is raising, and I was coming to that actual part in regards to the issue of the information itself. But if I may, Your Honor, that's one argument that we've had in regards to whether, in fact, there is a treaty right breach in regards to Trinidad and Tobago. The other position that we would like to put forward that we have in our submissions is on the issue of whether, in fact, there was a breach of the treaty right when the applicant entered into Jamaica. If I may say, Your Honor, the right to freedom of movement under Article 45, mentioned with the head of conference meeting in 2007, it is clear that the right of freedom of movement is subject to two somewhat restrictions or conditions. The first being that every member state has the right to determine whether a person may be deemed undesirable or whether a person may be a charge on the public funds. And I will address the information aspect, which my friend says Trinidad shared, and I will come to my submission on that point on the issue of charge. But again, in order to be satisfied the Article 222 of the Revised Treaty, my friend has to be able to satisfy this panel that there was a treaty right that was breached in relation to him, in relation to her. I'm sorry, forgive me. My lord, my position on that point is this, that every member state of CARICOM has the right to determine whether a person who is entering its country is a person that is undesirable or may become a charge on the public funds. Now, in this case, there was certain information that was in the possession of the Jamaican authorities that triggered, I would call it no more than an interview that all of us are subject to when we enter any country and present ourselves before an immigration authority or an immigration official. That immigration official interviews us and they conduct what they perceive to be necessary questions in order to make whatever determination they need to make that will permit us entry into the country. In this case, the Jamaican authorities had certain information in regards to the applicant, which resulted in a question being asked regarding criminal history and or any interference with the law. That is simply within complete the right of the receiving state to do. I do not believe that that questioning amounts to harassment or an interference. It is simply a country doing its due diligence in regards to whether it needs to determine if this person should be permitted entry into the country. Now, the information that the Jamaican authorities had at the time may not have been accurate, because at the time when she was entering Jamaica, she had been acquitted.
Counsel,
yes, Your Honor.
On that point, would you assist me?
Yes,
Is
Your
there
Honor.
any, or was there any litigation in Trinidad concerning the inaccuracy of this information which affected Ms. D'Almada? Was there any litigation in Trinidad concerning the obligation of Trinidad to not to have inaccurate information out there?
Not to my knowledge, Your Honor. I would say this. There were a few matters that the applicant had filed in Trinidad and Tobago. One was a malicious prosecution case. The other two matters that I'm aware of, or three matters, were FOI applications, where the applicant was trying to source where this information would have come from. And that those FOI applications came subsequent to the episode in Jamaica.
Right.
I do believe, Your Honor, that there is nothing that, of course, prevents the applicant from making that exact point domestically. if Trinidad and Tobago has shared information which is inaccurate and there's no evidence, and I have to confess, there is a bit of absence of evidence brought by what I would feel the claimant in the matter in regards to how this information came about. So, for example, one is not certain when the information was shared with Jamaica. There's no certainty. There's only a statement by the applicant on her evidence, her affidavit in support at paragraph 10, where she says that the immigration authorities told her that they have a sharing arrangement with CARICOM agencies. That is the extent to which we know it. We don't know whether that information was said much earlier when the information may have been valid and correct at the time.
Mr.
And so
Lala,
there
at
is
this stage, would the applicant be required to have conclusive evidence at this stage?
not conclusive evidence, Your Honor, but it does raise certain concerns regarding the statements that are being made that Trinidad shared inaccurate information. And I put caution to that, Your Honor, because I just want to be certain that the applicants have, well, if I may have one second, Your Honor, please. Just as a matter of distinction, Your Honor, the issue of the sharing of the information, if I may be permitted, the evidence that is before the panel comes from a variety of documents. Now, the applicant has filed an application, an affidavit in support, and has exhibited certain affidavits from other proceedings, the FOI proceedings in Trinidad, that does shed some light on the issue of the information that they were asking. There is evidence on those affidavits, which my friend has put before the court, where the Commissioner of Police has indicated there is only one system in which a person's criminal record is kept, which is at the CRO's office. Information is only shared upon a request. No request was made by any authority for any information regarding the applicant, and none was shared by the CRO's office. There's no other database that they keep this information on. So I hear things are being said in regards to Trinidad sharing information, but that affidavit evidence is before the court for its consideration. Now, I accept there's a judgment by Justice Margaret Mohammed where she chose not to accept that evidence. She accepted the evidence of another deponent, which is Ms. Harrison. But Ms. Harrison was not an entity that was named in any of the FOI proceedings. Ms. Harrison was brought in at the invitation of Justice Mohammed to get some clarification on the relationship between who shares information. And Ms. Harrison's affidavit is also there. And Ms. Harrison's affidavit would seem to suggest that the information sharing is between the Ministry of National Security and these other interregional state agencies.
But Counsel, if I may interrupt you, we are clear as to the question being open as to what was accurate information, from whom was it sourced, who is responsible, and all of that. Those are matters which, if leave is granted, will need to be explored. At this stage, what we are looking at is quite simply that there was allegedly reported to the applicant sharing of information. And what I am concerned about is quite simply whether the sharing of allegedly false, inaccurate, outdated information is something which can be laid in these treaty rights provisions at the door of Trinidad and Tobago, or whether this is something which is a matter for the domestic law of Trinidad and Tobago for its citizen to sue the state for wrongfully sharing information or sharing wrongful information, if that is what took place. So that is all I am inquiring.
Your Honor, our submissions have it firmly on our submissions that is a matter for the domestic courts to address.
Okay.
If my friends, okay, thank you. Sorry, we have the view. Yes.
Yeah,
Yes, Your
before
Honor.
you move on, the matter that was before Madam Justice Mohammed, Margaret Mohammed, was for
Yes,
what?
Your
Just for my own clarification?
It was also an FOI request that was made to the Attorney
A
General.
freedom of
So there was
information.
a freedom. Yes, please, Your Honor.
Yeah, and you said in addition, there were, I think you may have mentioned two FOIA applications, and you also
Yes,
said there
Your
was a malicious prosecution. So I
Yes,
take it
Your
that
Honor.
arose out of the acquittal on the cooking charge?
Yes, please, Your Honor. The malprose came out as a result of the acquittal of the cocaine charge. That is correct.
Yeah, yeah, I
And the
understand.
other FOIA is against the Commissioner of Police.
And those two FOIAs relate to the sharing of the information, how that information came to other countries or just within Trinidad and Tobago itself?
I believe it's to other countries, other regions, not to specifically. I can't recall, Your Honor. I will have to check, but it's certainly in regards to who they would have shared that information with. That is
And
part of the FOI request.
yeah, and is it that Madam Justice Mohammed was looking at who would be the proper authority to share that information under the laws of Trinidad and Tobago?
I believe, Your Honor, what the learned judge essentially did was come to the conclusion that that information must be with the state. She did not specify specifically which agency or authority, because the different agencies, which is the Ministry of National Security, they have the position that they don't hold that information. The Commissioner of Police's office says that while they hold some information, that information was not shared. And in regards to the Attorney General, that office indicated that we don't have that information, we're not in possession of that information, and therefore we do not share that information. And
Just for my clarity then, Justice Mohammed ordered what? And what is the status of
ordered that
her
this-
order?
her order, my lady, is reflected in the affidavit of the applicant. If I can find the correct page, please, my lady, I'll do that for you now. It's at page. It's at page 147 of 162. That's what I have on the top of my bundle. It was filed on the 6th of March, 2026. And it's at the end of her judgment. And if I could read it for the benefit of the panel and for my colleagues, it is ordered that the defendant breaches duty under Section 15 of the FOI for failing to take reasonable steps to notify the claimant of the approval or refusal of the request for information made on the 1st of February. That, my lady, is in keeping with the fact that under the FOI Act, you have 30 days in which to indicate whether you will be granting the request or refusing the request. And if you are refusing the request, why? If that's not done within a 30-day period, you have the right to bring a JR, and there was no response from the Attorney General in writing within that statutory permitted period, which is why that declaration is made in that sense. But there was an affidavit that was filed in the proceedings, which essentially answered what the evidence was on the FOI. The second part, though, is the claimant is entitled to the information in the claimant's request dated the 1st of February, 2023. And the third is the defendant shall provide the claimant the outstanding information in the claimant's request within 28 days of the date of the order. My understanding, my lady, is that because the AG's office said that they did not have that information, they could not provide the information. But that judgment and those orders are on appeal to the Court of Appeal now, presumably.
Thank you very much.
If I may, I'm so sorry, if I can just recap one point that Your Honor, Mr. Justice Barrow raised, is that we do believe that the issue of that information, even if it was wrong information, that is a cause of action that my friend has domestically within the jurisdiction of Trinidad and Tobago. And I don't believe it's something that respectfully a matter that can engage the CCJ in its original jurisdiction on that specific point. There's no right to privacy under the Revised Treaty of Chaguaramas. And I understand what my friend is saying, that privacy is a fundamental right, which we do accept that it being a fundamental right, but it's also qualified. And that qualification can be based on whether the sharing of information is done pursuant to a legitimate purpose, and the manner in which it is done with a reasonable and proportionate treatment of that information, Your Honor. So in regards to that same question that is being raised about the information that has been shared, our submission is that the Jamaican authorities have the right to inquire of somebody if they have information that that person is on a criminal charge, to inquire about that. And the person was able to satisfy the authorities satisfactorily that the information that they have is not correct. I have been acquitted. And that is exactly what that purpose is set up for. The interview, the inquiry.
Mr. Lala, if I may, because you're coming back to this, the same answer that you were giving me earlier about this right to determine whether I'm just putting it in my words, whether the traveler is undesirable or whatever. My question would be, if we were to make an analogy to the domestic jurisdiction, so this power, I suppose, that you're talking about, immigration officers have the right to check, police, law enforcement with domestically also have a power to stop and search, right? They have a power to arrest, etc., etc. Those powers we know domestically have to be underpinned by certain guardrails, reasonable suspicion, etc. Are there similar guardrails for this power that you are asserting by immigration officers? In other words, does it have to be founded on reasonable suspicion? Does it have to have a lawful base? Should the information be accurate? And if Trinidad shares this information, is that purely domestic, or is there no causal connection there?
Lord, I don't believe so, Your Honor. I don't believe there's a direct causal connection, if I may be permitted. The concept of the sharing of the information it is not uncommon that states share information with other states for security, national security, regional security reasons. And that is done throughout the region. It's done throughout many countries of sharing information. So I don't think that is an uncommon practice, or is it an illegal practice? It's done has a legitimate objective that underpins it. In regards to immigration authorities, I would say this, Your Honor, is that the immigration authorities get their powers from legislation and any applicable common law provisions that apply in their duties and performing their duties and functions. One of the things that our immigration authority will be entitled to do is make inquiries for their satisfaction that this is a person that I can permit into my country. So if it's determining that the person is an undesirable, because they have information that this person has a criminal charge, that is a legitimate lawful inquiry, and that is being done at that point in time.
Mr. Lala, Counsel.
Yes, Your Honor.
Please allow me to interrupt you here.
Certainly, Your Honor, of course.
Wouldn't these things be for the state of Jamaica to respond to in terms of what their immigration authorities did? I don't see how it lies in your mouth to answer my brother's very proper question by saying what immigration authorities need to do, how they should do it, etc. Leave that for the state of Jamaica to answer. Your response, it seems to me, to my brother's question is that all you all are accused of is sharing outdated, inaccurate information, which led the Jamaican authorities to improperly, unreasonably, and unnecessarily detain or hinder your client's entry, their client's entry by reliance upon outdated information. That's all, as I understand it, Trinidad and Tobago is allegedly on the hook for. Am I correct?
Well, yes, Your Honor, you are correct on that. Maybe I misinterpreted your Justice Falcon's question to me. I interpreted or understood it to mean that if they were acting under a lawful power.
Sorry, if who was acting under a lawful power?
The immigration authorities.
In Jamaica?
In Jamaica, that is
Well,
correct.
then this is the point. That's not your business.
Sorry. Yeah. If I could associate myself with the line of interrogation by my brother, and to go a step further though, to say, assuming that your business is the accuracy of the information that was placed into the regional container. Your response, I gather, to a previous question from him is that that's a domestic matter.
Yes,
and that should be pursued
yes,
in the domestic courts. But
Yes,
there
Your
is a case decided by this court in the original jurisdiction, TCL, which says that a national can sue its own state in the original jurisdiction. So is your suggesting that this is purely a domestic matter? How would you square that with the decision of the court in Trinidad Cement Limited?
In Trinidad Cement Limited, there was a treaty right that was breached in regards to that national, which allowed them to have the jurisdiction to, the locus, I should say, to bring the claim in the original jurisdiction against the state of Trinidad and Tobago. In this case, we do not think that is the situation, the position.
I see. Okay, I think your time is virtually expired. Is there any other point you wish to urge on us, please?
No, please, Your Honor. Thank you very much. I will rely on the submissions on the issue of cost that I believe the panel may have been inquiring about, but I'm grateful for the opportunity, and I rely on the rest of my submissions, Your Honor.
Greatly obliged and appreciated. Thank you very much, Mr. Lala. Mrs. Hall, for the second respondent, please.
Yes, Your Honor. If it so pleases you, the State of Jamaica will rely on the submissions filed on May 28, 2026, Your Honor, and we do not intend to regurgitate those submissions, but to highlight certain pertinent aspects of it that we believe that the court should have regards to in determining whether or not special leave should be granted. And our starting point in our response to this application is to say that the applicant has failed to satisfy the requirements under Article 222 of the RTC, that she has an arguable case that a treaty right has been infringed. And we say so, Your Honor, that there is no arguable case that the right of freedom of movement has been infringed. And in our submissions, we refer to the applicant's own evidence that we say support our argument that this right to freedom of movement, that it has not been breached or prejudiced in any way. I note that my friend in his submissions made reference to hassle-free travel, looking at the right in its qualitative sense. And we say, looking at the right in its qualitative sense, or indicating whether or not the right is hassle-free entry in the receiving state, does not mean that there is no inconvenience, or the state does not maintain the right to determine whether or not the CARICOM national that is entering is a desirable person to be granted entry. And so the first position of the state of Jamaica is that the evidence before this court clearly shows that the immigration process that the Jamaican Immigration Authority undertook was well within the acceptable and well within the rights of the state. Contrary to what my friend would have indicated, that it was non-routine border treatment. My apologies. We say that there's no evidence put forward by the applicant that the treatment meted out to her on entry was non-routine. We say it is routine. It is the normal immigration procedure and process in determining, as it is within the right of the state of Jamaica to do, whether or not the applicant was a desirable person to be granted entry. The applicant's own evidence.
Ms. Hall.
Yes, yes.
When you say this normal, you mean you're characterizing what the applicant has alleged in her affidavit about the secondary questioning, the 30 minutes, being presented with information. You're saying all of this is normal?
Yes, Your
So
Honor.
passengers are secondary questioning. Are you really saying that that's normal, or are you contesting that that this is somehow untrue? I'm not quite clear.
No, Your Honor. We're saying that the interview process is a normal process on entry of any passenger, that any CARICOM national that is entering the state of Jamaica.
If every person is subject to secondary questioning and a 30-minute, for 30 minutes, could that be true?
We're not saying that every person is subjected to secondary questioning, but we're saying that secondary questioning is a normal procedure in circumstances where there is information to warrant same. And in this particular case, the state of Jamaica had information to warrant the secondary questioning.
So, Ms. Hall, your submissions, paragraph 7, you cite Myrie.
Yes.
And you cite Myrie, which talks about the limits on this right to freedom of movement, and in terms of the restrictions. And you quote Myrie, which says, there is this right unless, and I'm quoting from your submissions,
yes,
unless the national presents a genuine, present, and sufficiently serious threat affecting one of the fundamental interests of society. Now, is there an obligation? And I asked Mr. Lala the same question because the same kind of argument he makes in his submissions. But when a state is operating under this, saying that there is a genuine, present, and sufficiently serious threat, which is the language of this court, is there an obligation that the information they're acting on must be accurate? Must they have, in the language of, as I said before, in a domestic scenario where it would have to be reasonable and proportionate, is there a similar obligation here?
There is an obligation to verify the information received, and that is what the state of Jamaica did. So the state of Jamaica is the receiver of the information. The state of Jamaica did not create the information. And so on receiving the information, the state of Jamaica was well within its right to investigate, if I'm using that word, the information which we submit based on the claimant's own evidence, the state of Jamaica did. And once the documentation was provided by the applicant, to clarify, to confirm the acquittal, she was permitted to enter and to move freely within the state of Jamaica. And we say that is hassle-free, that is no impediment, because we were in possession of information that would alert our immigration authorities that this person could potentially be an undesirable person. And so we did our due diligence. We did not act on the information by itself and prohibit entry. We took the time to ask the relevant questions. We got the information and we acted on the information in terms of allowing entry.
Thank you. Quite clear. So the state of Jamaica acted on the information that was there, so they relied on that information. So no breach by Jamaica. That's what you're saying.
No breach. No breach, Your Honor. And we find support because yes, we have mentioned we have relied on the Shanique Mary's case and the pronouncement on the nature and extent of the right to freedom of movement. But we also in our submissions made reference to the Gilbert case, which we say is very relevant to these particular facts that the court is assessing.
So to take your response then, I mean, thinking about it, there would therefore be, since you're acting on that information, and that information leads to a certain consequence in terms of what Jamaica's doing, it is important that that information is accurate. Yes, you would agree with me?
Query indulgence. Most certainly, Your Honor, and that is why we did not rely solely on the information. That is why we went further in verifying the information. Mm-hmm. So this is not a situation where the state of Jamaica relied solely on the information received. We went a step further in the verification of the information. And what we have submitted is that the applicant, in order to establish the case of arguability, would have to do more. It is not a simple situation of indicating that she was subjected to secondary questioning. She would need to go further, as this court has said in the Gilbert case, to say what, in addition to this questioning that the immigration authorities in Jamaica subjected her to, which was outside of the norm. And that is our position. And we want to refer the court in particular, because we think that it is applicable in this case to paragraphs 23 and 24 of the Gilbert case. And if I am permitted by the court, I would want to read what this court has said in the Gilbert case.
Please go ahead, yes.
Very well. And just paragraph 23, the last line of paragraph 23, freedom of movement under the RTC does not immunize CARICOM nationals from the operation of law enforcement agency in the receiving state. And in this particular case, we would say it does not immunize the CARICOM national from the operation of immigration officials in conducting their screening process. And at paragraph 24, the court went on to say, in the judgment of the court, therefore, more would be required before the applicants can make out an arguable case that their detention by the police in the circumstances of this case prejudice the enjoyment of their right to freedom under the treaty. But what more would be required? In this case, the applicants have alleged that they were treated in a wholly disproportionate manner, but in order to show a breach of the right in question, the applicants would have had to demonstrate that in their arrest and detention, there was some element of discrimination based only on their nationality. In other words, a breach of the community national rights to freedom of movement within a receiving stage should be premised at least to some extent on treatment that is discriminatory on the ground of nationality. And we want to adopt in its entirety what the court says in paragraph 24. And we say that this case falls squarely within paragraph 24, because what we have here is the applicant saying that she arrived in Jamaica. She was asked some questions that lasted, well, the period lasted 30 minutes. She produced documentation and she was allowed entry. She has not made any allegation in terms of discriminatory treatment by the immigration officials. She has not made any allegations in terms of harassment by the immigration officials. She has not even go further to say the secondary questioning that she was subjected to was outside of the norm. There is no evidence before the court in relation to that. And taking into account what the court has said in Gilbert, that more is required than mere. And in this case, we say there was no detention. It was an interview process. We say more is required from the applicant to establish arguability, which is what the court requires on a special leave application.
Thank you very much. Is that it, or is there anything else you wish to say?
Yes, just one further point that we made in our submission, but we just want to highlight, and I know my friends from Trinidad indicated it, that the applicant has couched her case to a large extent to the right to privacy. Yes, she has indicated that the sharing of inaccurate information affects her right to freedom of movement. But if it is that she cannot establish that her right to freedom of movement has been infringed, then we submit that her entire case falls apart. Because the right to privacy is not a treaty right. And so the starting point is that the applicant would have to establish that the right to freedom of movement was prejudiced, and we say that based on her own evidence, there is no support for that assertion. And if it is that the court has no further questions for us, we will comment to the court in its entirety the submissions made on behalf of Jamaica in its written submissions, and yes, and rest on those submissions, Your Honor.
Anything on costs, Ms. Hall, briefly?
Yes, Your Honor. We say if it is that the court finds favor with our arguments that there is no arguable case, then costs should follow the event and costs should be awarded to the second respondents against the applicant.
Very well. Thank you, ma'am.
Grateful.
Attorneys for the third respondent, the Caribbean community, please.
Thank you, Your Honor. And like my colleagues before me, I would adopt the submissions that we filed in this matter in their entirety. Unless there's anything I can add to what has already been said in terms of arguability and making out an arguable case, both the state of Trinidad and Tobago and Jamaica have canvassed that widely, and the CARICOM Secretariat submissions reflect that. So unless there's something that you would like me to specifically speak to, I will adopt those submissions in writing and move to another point, if I may.
Please
so,
do.
Yes, thank you. One of the issues before us is this memorandum of understanding for the sharing of intelligence. My learned friend for the applicant has spoken to a non-treaty compliant framework. What he has not done, however, is pointed us to anywhere where the framework that has been established is in fact non-treaty compliant. Compliance on the effect and the implementation of the treaty rests with the memorandum of understanding rests with the member states. But out of an abundance of caution, Your Honours, I would like to read from the memorandum of understanding the definition of information. And this is found on page 2261 of 2281 of the bundle. Information includes unevaluated material of every description derived from any source, whether open or public, true or false, accurate or inaccurate, and includes the results of observations, surveillance, and rumors. This is how broad the definition of information goes in the Memorandum of Understanding. So whether or not the information is accurate, inaccurate, true or false is not a matter that member states in receipt of information are possibly in a position to question. The role of the community in this particular matter, and specifically the role of impacts, who is not a party to this, the role of impacts in this scenario is to receive information and to disperse it across the community as it sees fit according to the terms of the MOU. What the MOU does not do and what impacts does not do is tell member states what to do with the information that they receive and how to treat with persons. That is firmly couched once again in the MOU, which speaks specifically to the laws of the domestic state. So impacts is neither the creator, the author, the verifier of information. It merely receives it. If there is an issue with updating information, that is certainly not an issue for the community. And I feel strongly that we have not been told anything by the applicant as to how the treaty, how the MOU, how the arrangements of the community have breached his client's treaty rights. It cannot be that impacts, there's been no challenge to the formation or the operation of impacts. There's been no challenge to the formation or the application and interpretation of the MOU. So I am unclear as to what exactly the claim against the community is at this stage. In terms of whether an applicant was treated as a routine and non-routine border matters, I will take my guidance from Justice Barrow. This is not a matter for CARICOM, that's a matter for Trinidad and Tobago and a matter for Jamaica as to how the person was in fact treated. All we can do, Your Honours, is rely on the jurisprudence of the court as it stands. We adopt the findings of the court in Myrie as setting out what the scope of freedom of movement is. We also adopt the findings and the conclusions of the court in the Tamika Gilbert case as to the immunizations of persons entering states. We also rely completely on the Revised Treaty of Chaguaramas that provides a broad exception on matters of national security. Furthermore, Your Honours, I think some consideration has to be given as to the treatment of information received and the liability or responsibility of the community agencies and the staff that work there. It would be remiss of me if I did not point out that there are security concerns. Sources of information cannot be shared, cannot be revealed. And this is something that we have to bear in mind. And I would bring that to the attention of the court. I don't believe I have anything further to add at this stage based on the submissions that we've made and in response to the arguments made by my learned friend at this time, and I'm open to the questions from the court or further clarification that I can provide.
President, if I may?
Please, sir. Yes.
Counsel, what relief or remedy do you understand the applicant to be seeking in their application to this court if special leave were granted? What relief or remedy in relation to CARICOM is being sought?
Your Honor, I am not entirely clear on that myself, because I'm not entirely sure whether or not what the applicant is seeking is that the CARICOM review the operations of impacts, or that impacts review its own operations, or whether there is a review of the MOU. I'm not entirely sure what remedy the community can provide.
Well, the question is any of those things which you mentioned asked for? Because I do not see any of them asked for.
They absolutely are not, Your Honor.
I just wanted to be sure I am not missing something. We will, of course, ask Mr. Hemans when he replies, but I just wanted to get your view in relation to it. Thank you.
Council, just seeking clarity on something. In the written submissions in reply, I believe it is of the applicant at paragraph 17. The applicant states that at a case management conference, the community had asserted that impact should be substituted as a defendant in place of the community. I just want to first ask if you could respond to that, and then I may have a follow-up question. Thank you.
Thank you, Your Honor. What was in fact said at the case management conference is that perhaps the proper party for the matter would be impacts, subject to the jurisdictional issues raised by Doreen Johnson and CARICAD.
So, Council, I do have a follow-up question then. Now that you have raised Doreen Johnson and CARICAD, in its submissions, the community would have pointed to some dicta of the court. I'm looking at paragraph 15 of the community submissions. The community would have pointed to some dicta from the court in Doreen Johnson. I'm largely going to refer to the final sentence quoted, which states that the acts and omissions of institutions and associate institutions of the community are not necessarily attributable to the community, as are the acts and omissions of the organs and bodies. What I wanted to ask here is, to what extent do you think that statement resonates with respect to an institution like Impacts that would have come about based on a protocol to amend the revised treaty to establish security as one of the pillars of the community? I may have some follow-up questions. Thank you.
Thank you, Your Honor. I think it applies possibly to a greater extent than it may apply to other institutions or associate institutions of the community. Matters of national security require special treatment, and it would be inconceivable for the community writ large to have to bear the responsibility of the acts of omissions regarding matters of national security being conducted by member states through a specialized agency that has intelligence, has expertise that deals specifically with that area. The community in and of itself, as the member states that make up the community, within the architecture of the community, that responsibility cannot then shift out of that very narrow and confined expert space.
And then, Council, again, bearing in mind that I'm also noting the importance of the questions posed by my brother, Justice Sparrow, about the specific claims being made in relation to the community and any relief being sought in relation to the community. I do have a follow-up question. Now, the revised treaty would have been amended by this protocol I'm referring to. And one of the amendments would have established CONSLE, the Council for National Security and Law Enforcement, and would have made clear that one of the mandates, responsibilities, so to speak, of CONSLE would be to establish and promote measures designed to gather, share, and manage intelligence. It's one of the mandates of CONSLE under the amendment to the RTC. I just have a basic question here, which would be, to the extent that there is an assertion that the proper enjoyment by a community national of the right to freedom of movement is predicated on a treaty-compliant framework for the sharing of accurate intelligence or the sharing of accurate information. Is there any responsibility that CONSLE has under the revised treaty for that? Thank you.
I think CONSLE has derogated that authority and responsibility to Impacts. And the creation of the framework is buttressed by the MOU. And one of the, I mean, I read it before, but the obligation for the information to be accurate doesn't apply. The MOU is very clear on how it defines information. But I believe that the framework that was set up gives the right amount of authority and independence to safeguard against interference that agencies like Impacts must have in order to fully discharge their functions. Consulate's oversight is one of policy and direction. There has been no attack on the policy or direction given by Consulate. There's been no suggestion anywhere that Consulate has acted improperly. And I may go so far as to say there has also been no allegation that Impacts has acted improperly. There's been no suggestion of that. So once again, and following up from Justice Barrow's question and your other question, is that there has been no relief specifically sought against the community in relation to this alleged breach of the right to freedom of movement.
Ms. Permanent,
Yes, Judge.
I suppose in his reply, Mr. Hemans will respond to those questions. But in terms of since you have alluded to it again, isn't in an architecture where there is this system and you have Consulate at the top of it, perhaps providing policy directions and so on, isn't part of the case or what the applicant seems to be saying, I know you said you're not clear, is that these mechanisms must have appropriate safeguards, they must have guardrails, they must have mechanisms for updating and so on. And is it fair for each institution to sort of wash their hands and say, well, this is not my area. I'm not, concerned with enforcement. I'm not concerned. I'm only concerned with policy, et cetera, et cetera. And so what is left is a mechanism that has been set up without any apparent accountability by any institution. Shouldn't inbuilt in this be some kind of mechanism for the kinds of things that the applicant is talking about, ensuring that there are laws and procedures or safeguards to guide that? Are you saying that no arm of certainly Consulate who's directing policy would have no obligation in this regard? Just curious about that.
No, not at all, Your Honor. That's not the submission of the community. The responsibility for the information is not the community's responsibility. The responsibility for the information is the member state's responsibility. Impacts has discharged the responsibility it has under the community architecture. The community through Consulate has discharged the responsibility it has by setting up the framework. The compliance and the activities within that framework rests with sovereign member states. If a member state chooses to be delinquent in updating information, I don't know how that becomes the responsibility of the community or Consulate or Impacts. Impacts is not vested with investigative powers to make inquiries, to follow up on every case that is reported to them. There is the obligation on member states to do what they are required to do. So it is not that the community or anybody is washing their hands, Your Honor. That is not the position at all. But the safeguards that you are asking for are built into the appropriate responses made by member states in activating these agencies on their behalf.
Thanks, Ms. Permanent. I'm not asking for safeguards. It's the applicant's case I was trying to understand.
Yes, of course. Thank you. Sorry.
Anything further, Ms. Permanent?
I have one thing further to say, Your Honors, in relation to costs. The applicant based his response to your question in saying that the pre-application conduct of the party and spoke to seeking information from Trinidad and Tobago and Jamaica. What is noticeably absent is that they sought no information from Impacts nor the community. So the community takes strong opposition to any suggestion that we should be made to pay costs to the applicant should they be successful, but strongly advocate that we be granted our costs should leave not be granted. Thank you.
Thank you, ma'am. Just checking to see if there's any further question from my colleagues. There being none, I would then ask Mr. Hemans if he wishes to reply.
I do, Your Honor. I'll
Okay,
probably
so in your reply, Mr. Hemans, in relation to Trinidad and Tobago, I'm very interested in your take on the point made by Mr. Lala that really your quarrel is a domestic quarrel. Your issue about the accuracy or lack thereof of the information in question is a matter for the domestic courts in Trinidad. It should be litigated there, and it should not really be the subject of litigation in this jurisdiction. And I sought to bring to his attention the case of Trinidad Cement Limited, which suggested that it is possible for a national to bring an action against his or her own CARICOM state, so that to say it's a domestic matter may not be the end of it. Of course, he cited a more recent, very recent case, Bhagwan Singh, which suggested in that case that the national could not bring an action against his state of Trinidad and Tobago. So there seems to be some tension between the decisions in Trinidad Cement Limited and Bhagwan Singh. I don't know whether you see it that way, but assuming you do, or I could invite you to look at it from that angle, how would you respond to how that tension, if there is one, ought to be resolved?
Well, I mean, I think I think that the issue as it relates to whether a state can or cannot, sorry, whether an individual can or cannot bring a matter against its state is going to must necessarily turn on the facts, because there is no bar in the express bar in the treaty preventing a national from bringing a claim against its state. And it is not inconceivable that a state can conduct itself in such a way that ultimately leads to one of its nationals being able to access a right under the treaty. I'll give you by way of an example. I mean, this is a hypothetical. It's a hypothetical. If, for instance, Trinidad were to put in place such like impediments at a national level that made travel almost impossible for a national who wanted to travel to Jamaica, wanted to travel to Trinidad, not Trinidad, wanted to travel to Barbados, that would trigger the treaty, because and again,
I think, Mr. Hemans, I don't want to delay you very much, because if leave was to be granted, we could spend some time on this. But I invite you to consider the requirements of Article 222. That is, as I understand it, the gateway to the grant of special leave to individuals to bring action in the original jurisdiction.
I do.
So the statements in Article 222 are statements of law, not of fact, of law. And therefore, to bring, unless we're saying something different, but my understanding is to bring the matter in the OJ, the CARICOM national must satisfy the requirements of Article 222. Would you agree or not?
I agree, Miller.
Wonderful. So those requirements are stated in legal terms. They're not factual terms. They are, I think, we could concede that there might be some elements of fact and law, but substantially they're stated in legal terms. So I'm not sure I agree with you when you say it depends on the facts. I think the first and foremost case has to be one based in the requirements of 222 and whether those requirements are fulfilled or not. They may be fulfilled, of course, or they may not be fulfilled. But surely this is a starting place for that discussion, is it not?
I would agree, and I admit to being somewhat at a loss, Your Honor, just to the extent that for instance, there is no express bar in 222 against a national bringing a claim against its own state. There's no express bar as a matter of law.
I think we could, again, sorry not to interrupt, but we could debate that later if the opportunity arises. But if you read the content of 222, one could, I think, make the argument, whether it is successful eventually or not is another matter, that there is in fact quite clearly a bar. Now, as I said, I don't know we need to go into it right now, but if there's a requirement, for example, which says that the state is the one who has the right to bring the action, then I do believe that there is a question there, given the history and the traditions of diplomatic protection, as to whether a national could bring such an action against his or her own state. Ultimately, I think it's a matter of what the framers intended, clearly, but their intention as set out in 222, I would have thought, would have to be satisfied in respect of each attempt by a CARICOM national to bring an action in the OJ. Could we agree on that?
I agree that it is a thorny issue. I agree that it is a
I don't recall saying that, so I'm not sure what you agree with.
well, okay. Like I appreciate what the concern that is being raised by the court. What I will say, however, is that it is at this stage the court should look at arguability, and I think that it is arguable that in the present circumstances, it is just for the court to grant leave to deal with the issues as they arise on the present facts. And I know that the court has drawn the distinction between this whole matter of fact and law, but I don't believe that there is a broad rule. Certainly, the jurisprudence of the court doesn't suggest that there is a blanket rule suggesting that a national may not bring a claim against its own state. And each case.
On the contrary, Mr. Hebans, TCL since 2009 said you could do that.
Exactly. Well, it said you cannot. So TCL, the jurisprudence of the court is that you may. And
so I would have thought you would have mentioned that much earlier. But anyway, carry on.
Well,
before you carry on, I must remind you that more recently, I think it was it this year? 2026? In Bhagwan Singh, there are statements suggesting that it's difficult for a national to satisfy some of the elements anyway in 222. So I think, and this is what I was trying to get at with Mr. Lala, there appears to be, it might be an optical illusion, but there appears to be the possibility of some tension between TCL and Bhagwan Singh. And if there is that tension, would you say that that is the basis for arguability for saying, well, look, we need to try and resolve any tension that exists?
I would say yes.
Yes.
And further. I
thought you would.
And further, Your Honor, there are a number of these similar kind of broad-based issues that do arise, and we do know, starting in Myrie, especially in Myrie, that the court will give consideration to the nature of the issues that arise and use it as an opportunity to develop the jurisprudence of the court. So that is one factor, I think, that weighs in favor of the applicant here.
Yes.
Your Honor, I want to address your point, and there are some other aspects of the my learned friend's submissions that I did want to get to, but I do want to reiterate that I think that this particular case is one instance where it shows that the right to freedom of movement, given what the right entails, there are clearly circumstances where the state of the individual, the state of the applicant or the prospective applicant can take measures that impair the enjoyment of that right. And yes, some of those issues will sound in domestic law, one, but others can sound
You see, sorry,
in.
Mr. Hemans, not to interrupt, but you see, when you say the domestic court or the domestic state, I'm sorry, can take measures that would impair that right, you, with the greatest of respect to you, you may be assuming a question which has yet to be decided. The question is whether what is the right you're talking about? And is that right one that is a treaty right, which is what you're assuming, or whether it's a right under domestic law to be litigated domestically? So
Well,
you can't
okay.
assume that this is a right, a treaty right, which the state is breaching. The nature of the right is a thing that we need to examine.
The only concern I have is that and it is raised expressly in the submissions of the state of Trinidad and Tobago.
Yes.
Almost setting up this requirement, which is this requirement for exhaustion of domestic remedies, or the impermissibility of parallel remedies, meaning remedies existing at the municipal level and remedies existing at the level of community law. I am not. Our submission obviously is that there is no necessary tension between the two things, and there is certainly no requirement as obtained in other human rights courts, but which have a different architecture. Well, not other human rights courts, in human rights courts, because the CCJ is a unique beast in that regard. There is no
sorry,
creature, unique creature.
That's a little better, but I'm still not very happy. But go ahead, please.
I beg your pardon. It's a unique creature. Institution. It's a
Wonderful.
unique institution.
Thank you very much.
In that regard. I thank you, Your Honor. It's a unique institution
Welcome.
in that regard. But there is no requirement, and nor do I think it is desirable for there to be this the introduction of the requirement for exhausting local remedies. The regional Treaty of Chaguaramas is it's sui generis. It is its own thing. There are certain rights that apply at the level of community law.
Yes.
And those rights are run parallel as it relates to remedies at the municipal level and so on. And
yes,
so,
okay.
Yeah.
I think we, unless my colleagues, I think we have you on that.
Okay.
In relation to Jamaica is saying, look, we understand that your client was interviewed for 30 minutes or so. 2 questions were asked. We acted on the basis of information that we received in the galaxy, the impacts context.
Yes.
Galaxy of the impacts. So what have we done wrong? We did not detain your client for 2 hours or for 3 days or whatever. We did not send her back to Trinidad. I mean, all we did was to do maybe non-routine or secondary questioning. So are you sure you want to retain the application against Jamaica in light of what Jamaica said, including, of course, the reference to Shanique Mary, Gilbert, and so on?
Yes, we do, Your Honor. There are two elements to this matter. One, you have the factor of the half-an-hour questioning, and then you have the whole matter of her colleagues similarly being detained and being informed that the reason for their questioning was as a result of Miss Almada. So it was done under embarrassing circumstances. And I think that there is a it is being presumed that, well, first of all, it is being conceded by Jamaica on the basis of their tacitly conceded that they have a duty to verify that the information is accurate. Firstly, now it is being presumed that the only way, or that a treaty compliant way, is to have that verification take place at the border and require the individual who has a right of direct entry to prove that they in fact are not an undesirable person. Now, we are suggesting that we have made out an arguable case that that is not the way that that verification process should properly take place. And it all feeds back to our broader contention regarding adequate and treaty compliant safeguards in terms of the sharing, the storage.
Counsel, help me here. What makes that duty to verify a duty owed under the treaty? What makes that duty not a duty that the law enforcement officers, the immigration officers of Jamaica have to conduct their business fairly and according to law, reasonably, etc., so that whether they got information from a CARICOM organization, a fellow CARICOM state, or from the United States of America, or England, or whatever, any information that they got which triggered an alert, they would have a duty to inquire into whether this information is accurate. So that is their duty, not a duty owed as part of the CARICOM Treaty. That is how it is striking me, and I invite you to improve my understanding.
Well, forgive me if I misspoke. What I'm trying to convey is that the actions of the Jamaican immigration authorities need to be treaty compliant. And if...
Sorry, why?
Well, because once we're talking about a CARICOM national who is entering another member state, they are exercising a right that is guaranteed under the treaty that this court has indicated includes a right to direct and hassle-free entry. And so while we the typical situation at the border is that immigration authorities have a broad discretion relating to whoever can come into their country. Right. We're suggesting that one of the implications flowing from the Treaty of Chaguaramas is that discretion is narrowed and must be administered in not only in accordance with the letter of the treaty, but also in accordance with broader human rights, international human rights principles, of which privacy is one.
Counsel, following your line of argument, what you are saying is that Jamaica had a duty under the treaty to ensure that the information which they got from a fellow treaty country was accurate information, and that information conveyed to them was accurate. Is that what it comes down to, it seems to me?
No, what I'm suggesting is that Jamaica has a duty to verify the accuracy of the information. Now,
sorry, hold on. Which they did in the interview with Mr. D'Almada.
Well, so our contention is that there is an arguable case that the manner in which it was done is not treaty compliant. It was not done in a dignified way. It's not the only. It's not even the. For instance, why couldn't the Jamaican authorities have simply asked the applicant a question and be done in 5 minutes? Why couldn't they have asked a question of Trinidad and Tobago? Why aren't there mechanisms in place to ensure...
The easiest thing, Mr. Hemans, you and I have been through immigration lines before. We have seen people where the flag goes up at the immigration booth and some other officer comes and takes the person from the immigration booth into another room, and whether it takes 5 minutes or 10 or 15 minutes for the interviewing inquirer to reach and ask the question. That is simply a part of the process. So it is that the process took half an hour. Yeah.
And you see the question though, is really, and this is why we think this is an arguable case, because this is an opportunity for the court to fully flesh out what is the standard of treatment that ought to be meted out
by immigration officers to CARICOM nationals entering.
Border treatment. Yes,
I
it
see.
is. It really
All right.
is.
Yes.
I hear what you're saying. You have answered my question.
And so do I, and so do I. But the point, Mr. Hemans, is that we should be careful about using opportunities to, as you said, flesh out jurisprudence on the backs of parties who ought not to be subjected to that exercise. So would you agree that if you were to proceed, and if Jamaica was a party, and if at the merit stage Jamaica satisfied the court that it did absolutely nothing wrong, that there would be an implication for costs for your client? It would be reasonable for us to interrogate that question. Would you agree?
I would say that would be reasonable in any case.
Let me throw this out to you on top of that argument. If this were domestic litigation, two entities belonging to the state in which you're conducting domestic litigation,
yes,
by all means sue the two of them, so that one cannot say it is the other whom you did not sue who is responsible. So that two-pronged approach in domestic litigation, I think is a sound one. Now, when you're dealing with a situation where these are two separate countries and you're suing them in relation to treaty rights, I don't know how sound that approach can be. For the similar reason, you joined CARICOM. By all means, if this were domestic litigation, join everybody. And if I win against one and lose against the others, ask the court to argue that the party who has lost against me pay the costs of everybody. That would be good. But this is not quite that, you see.
Yeah, I don't know that we were as cynical as we're as cynical as that in our consideration.
What remedy are you asking against CARICOM?
Well, the remedy against CARICOM, Your Honor, really relates to the information that is contained in the database.
No, it relates to, but what remedy are you asking for?
No, we've asked for the information. We've asked for information to be removed from the database, which we submit is a policy.
No, hold on.
Policy question.
Watch me. You're asking the court to order CARICOM to do something in relation to the database?
Yes, we are.
Really?
Yes, we are.
I didn't understand that. I am better informed.
May I?
Yes, please.
Craving the court's indulgence. Right. So, if you look at page 7 of the record, and it's contained in our application, in our originating application. Let me read it before I start reading it out loud.
Yes,
Craving the court's indulgence. Right. So if you look at 4, we ask for an order of mandamus compelling the defendants to irrevocably delete all information relating to the claimant's criminal charge from files or databases in the control of the defendants, or in the alternative, an order that the defendants accurately record the status of the criminal charge. Now, I want to tap onto that to kind of. So there's something that CARICOM said. The counsel for CARICOM, I learned it for, and I beg your pardon, said regarding the MOU. It was suggesting that the MOU says that information can be unevaluated, it can include rumors, and suggesting that whether the information is accurate or not is not an issue. And I think that kind of speaks to an attitude or a mood that relates to the challenges that we had in bringing this case.
I understand your difficulty. Please come back to my question. What remedy are you asking in relation to CARICOM?
We're asking for CARICOM. We're asking for CARICOM as the entity with broad policy control of impacts to see to it that the information contained on whatever regional networks that exist, information contained about the applicant, that it is removed.
Sorry, and you're paraphrasing from what document?
I'm paraphrasing from our originating application. That's at page 7 of the record.
Page 7, and which number?
4.
And order mandamus compelling the defendants to
Yes,
irrevocably delete all information relating to the claimant's criminal charges from files or databases in the control of the defendants, or in the alternative, an order that the defendants accurately record the status of the criminal charge. Can you get such an order against CARICOM?
Well, we have put it here because we think.
I know you have put it there, but I'm asking if you can get it.
We have put it there because we have put it there because we think we can, and I can say, Your Honor, that absent evidence relating to the nature of the mechanism as exists, it is almost challenging, and the operation of the information sharing architecture, it is challenging to even determine who is exactly at fault and what remedies we can obtain from each. What we say, however, Your Honor, is that undoubtedly CARICOM has broad policy control of impacts, that impacts as well as the state of Trinidad, the state of Jamaica, deals with a database that foreseeably touches and concerns border treatment decisions, and as such, it has to be administered in a manner that is compliant with the Regional Treaty of Chaguaramas.
Mr. Hemans, I will pay tribute to you for that answer, and I will not charge you with going any further. I think you have done the very best you can in the circumstances. You should feel quite pleased with yourself. I may not think that it is a wholly convincing to me answer, but it may convince my colleagues. So I think well done.
I would just add, in addition to the praise heaped on you, Mr. Hemans, that we should remember that this is a fairly serious matter. This is a matter of national and regional security. And obviously, you know, we would have to hear from those persons who are expert in the field. There are things that would test the boundaries of disclosures and so on. So I just want to be sure again that you will persist in the application against CARICOM. So against all 3 persons. Is that your position?
Your Honor, so we have brought this case, the applicant has brought this case because we do recognize that it raises some important issues about rights related to freedom of movement. Now, as it relates to CARICOM, I am happy to confess, or to reveal rather, that we are not clear on the relationship between CARICOM and impacts, and it may be that impacts ought properly to be joined in the matter. Our position, though, is that I don't think it would be safe, if we are granted leave, to not have CARICOM here, especially in circumstances where we have the MOU sets out plainly that CARICOM does have broad policy control over impacts. What that entails, we're not sure, and that is not necessarily something that ought properly to concern the court at this stage, because the court should concern itself that there is an arguable matter to be tried. And we think that there is an arguable matter to be tried against all the respondents that we have named, and perhaps others besides.
Oh.
And no. I suppose I don't know if this is this is probably breaching some protocol, but we in our submissions we did invite the court to of its own motion join impacts if it considered it necessary. And I don't know if we are granted leave, if that is something that could potentially be done later, depending on what arises. That's one. And secondly, I appreciate that we are likely to come up on some very sensitive issues relating to disclosure and so on, but I don't know that is that's a matter at the level of evidence, and I'm not sure that is something that we should necessarily concern ourselves with. What we should be concerned here is that there is that the claimants have made out, and the applicant rather has made out an arguable case that she has been prejudiced in the enjoyment of a right that inures to her under the treaty. We say she has. The right is the right to freedom of movement. The right to freedom of movement is not a narrow thing that relates only to being admitted into a territorial member state. It includes border treatment. And if you have a regional information architecture that foreseeably will impact on the border treatment, then how that whole architecture is managed has to be done in a way that is itself treaty compliant.
Yes,
yeah.
I think we have you perfectly well, Mr. Humans. Thank you very much. I think we will take a break. We've been going for a little bit. Maybe for about 10 minutes or so. We'll try to be back in 10 minutes. If you will, please, all parties, stay in place, perhaps with your cameras and audios off. And we'll come back to you in about 10 minutes or so with an update on our thinking. Thank you very much. Registrar?
Thank you, President. The matter stood down. Matter is now recalled, President.
Thank you very much. Well, the panel would like to thank Council for their very learned submissions, which we found very, very helpful indeed. We'll give our decision now, and then we'll give reasons for that decision later on. The decision of the panel is that special leave will be granted for the application to proceed against all three respondents on the basis that the applicant has satisfied the test in Article 222 of the Revised Treaty requiring arguability that the application will succeed on the merits. The panel wishes to emphasize that the grant of leave does not make any final determination on any of the issues that have been posed before us. All that we are saying at this stage is that the questions raised are arguable. The issue of costs, of course, I think we agreed earlier, will be folded into the hearing on the merits. Now, we are proposing a schedule that would lead to us hearing this matter on the merits. And I invite our Judicial Counsel, Mr. Sakal, to display for us the proposed schedule leading to that hearing. And if he would be so kind as to take us through the various milestones leading up to the hearing. Mr. Sakal, please.
Your Honor, before we do.
Yes, who is this, please?
This is Kashka Heman. I beg your pardon. This is Kashka Heman's, Your Honor. I just wonder if the court had ruled on the applicant's application for the waiving of the fees. I think that was something that was specifically waiving of the fees, the court fees. Filing fees, I beg your pardon. Filing fees.
The filing fees, yes.
Filing fees, I beg your pardon.
No, we have not deliberated on that, but we could do so at a time that would not cause you too much inconvenience, I'm sure.
That's fine.
Thank you, sir. Mr. Sakal.
Yes, President. Very briefly, if you look at the table, on the left-hand side is the proposed step, on the far right is the proposed date. I'll focus on things highlighted in yellow, which I consider to be more of the important proposed timelines. So given that the court has granted special leave, the applicant has 7 days pursuant to Rule 10.51 to file the originating application. So the latest date would theoretically be Monday, the 13th of July, 2026. Yes, President, could I continue? I saw you
Please
raised your hand.
do, yes. No. That was another engagement I had. Council, may I say that these are simply proposals at this stage? If you agree to them, then they will be embodied in the order of the court, which will be issued in due course. So please continue, Mr. Sakal.
Following from this, defenses with an extra served would be due within 42 days of service. I'm not sure what day it would be served, but give or take, this should be close to the latest time period, Wednesday, 26th of August, 2026. Following that, the court has a vacation up until Monday, the 5th of October. A proposed date of case management conference regarding this matter is Wednesday, the 14th of October, 2026, time to be specified later. At the case management conference, the court will give further directions regarding these other matters listed on the left: the disclosure of an inspection of documents, agreed statement of facts, written submissions of both claimants and defendants, and these on your right are the proposed dates: Tuesday, the 3rd of November for agreed statement of facts, Tuesday, 10th of November for the claimant's written submissions, Tuesday, 24th of November.
I'm sorry, sir. Could we pause there to ask whether there are any difficulties so far with the requirements and the dates? Any difficulty that you've seen, counsel, for the applicants or the respondents?
None so far, Your Honor. I am trying to confer with Mr. Murray but so far none that I can see.
Wonderful, thank you, sir. For the respondents?
Your Honor, in regards to the filing of the defense, I believe it will fall during the court vacation. My concern is that we're in July and we tend to have a very heavy, demanding court schedule towards the end of the close of the court term. And it does make it a little bit difficult, with the pressures of the current workload that we have, Your Honor, that I may have asked for some more time in August for consideration of the filing of the defenses in this matter.
Yes, thank you, sir. To what extent are we controlled by the rules here, Mr. Sakal?
Well, if you'd allow me a moment, I could pull up the rule itself, but it's 42 days from service. So it's dependent, I believe, on when it is actually served upon the defendants in this matter. If you give me one moment, I could pull it up.
Yes. You see, Mr. Lala, the point is that your filing of the defense is related by the rules.
I understand, Your Honor. I see
the
that.
serving of the OJ, OA. Yeah. So I do not know whether you would be in touch with counsel with a view to arranging for the filing of the revised originating application that would assist. Of course, counsel himself is bound by the rules in relation to the filing of the OA. Yeah.
Well, Your Honor, in the circumstances, I will endeavor as much as I can to ensure that we are within the timelines as currently set by the court.
Greatly obliged.
Grateful, Your Honor. Thank you.
Of course, if there are overbearing circumstances which emerge, one can always make an application to the court.
Yes, please.
It will be considered. Yes. Okay. Thank you.
Following that, the written submissions, if ordered, Tuesday, the 24th of November is the proposed date, roughly 2 weeks and a few days following the written submissions of the claimants. Written submissions in reply, roughly a week and a day or two after, and then a pre-hearing review on Tuesday, the 8th of December. The proposed date of hearing of the application, Tuesday, the 19th and Wednesday, the 20th of January, 2027.
Normally, we would have the first of those 2 days devoted to the hearing of the evidence, normally, and the second day to the hearing of the legal arguments. So that is why we normally have 2 days for OJ matters. So this is what we have in mind. Yes, I'm sorry, Justice Rashnath-Lee.
Yes, thanks, President. President, could I just ask Mr. Sakal then to go back up a bit so that is it that we provided for the filing of witness statements, or that is a matter to be raised at the case management conference? Yeah, I would think so, because I'm not seeing anything concerning the filing of witness statements. Yes, thank you, President.
Yes, thank you very much, ma'am. So that is what would occur, among other things, at the CMC. Now, I know that this has been sprung on you very much a short notice. So what we propose to do is to place this in the form of a draft order and transmit it to you. We are hoping that there is not a lot of requests for changes, because that would involve probably having to hold another CMC. But we will not finalize it until you have seen it again, you're comfortable with it. And once you are in that state of mind, we will perfect it and send it out as an order. Is that agreeable to counsel?
Yes, Your Honor.
Yes, Your Honor, for the applicant.
Thank you. For the second respondent, now defendant.
Yes, Your Honor, we'll look at the dates and indicate if we have any challenges.
Yes,
For
but prima
present
facie-
purposes, we might have a challenge with the January date, but we will await the do some more checks and indicate to the court definitive position.
very well, thank you. And for the third defendant? Caribbean community, is the provisional timetable to your
Yes,
agreement?
President, thank you. At this stage, CARICOM has no objection and will endeavor to meet the timetable of the court.
Thank you very much indeed. Is there anything further from council or my colleagues for that matter before we close?
Not from me,
Nothing, Chair.
President. Thank you.
None for me.
Nothing from the applicant, Your Honor.
Greatly obliged. Thank you. Very well. Madam Registrar, would you please close these proceedings?
Thank you to the Honorable President and judges of the court, to counsel, and to the staff of the court. The matter now stands adjourned.
Thank you.
Thank you very much.
Thank you.
Obliged.
Thank
Obliged.
you.